Welcome to LexAI, your AI-powered partner in mastering the law. We combine artificial intelligence, legal analysis, and jurisprudential insight to make complex legal doctrines clear, visual, and easy to understand. All right, today we're tackling Rule 81 of the Rules of Court, and this is all about the financial safeguards in settling an estate. Now, at the heart of it all is something called an administrator's bond. So what is that? Well, the easiest way to think about it is like a safety net, or maybe an insurance policy. It's put in place to protect everyone involved, the heirs, the creditors, by making sure the person in charge of the estate does their job honestly and by the book.
Okay, so here's our game plan for this explainer. We're going to start with why this bond is just so critical. Then we'll get into the interesting stuff, like what happens when the deceased person's will tries to say no bond needed. We'll also dive into situations with multiple administrators, the unique rules for a temporary special administrator, and then we'll wrap it all up with the court principles you absolutely need to know. Let's get started.
All right, first things first, let's jump right into Section 1, which lays down the most fundamental rule of all, and it's a big one. Before an executor or administrator can even think about touching a single asset, they have to, and I mean have to, post a bond. It's not a suggestion, it's the non-negotiable price of admission. And let's be clear, this isn't just a friendly guideline. In legalese, we call this a condition precedent. You know, it's a fancy term, but all it really means is that this bond is the key that unlocks all their legal powers. The logic is brutally simple. No bond, no authority. And who decides how much? The court does. It looks at the estate's value and sets an amount that's sufficient to protect it. So you might be wondering, what exactly is this bond guaranteeing? It's not just some vague promise to do a good job. Nope, it's a rock-solid commitment to 4 very specific duties. First, they have to inventory everything in the estate within 3 months. Second, they have to actually manage the estate, pay off debts, give out inheritances. Third, they need to provide a complete accounting of where all the money went. And last but not least, they have to follow any and all lawful orders from the court. All right, time for a little check-in. Let's see if we've got this down with a classic scenario you might see on an exam. So picture this. The court is all set to issue the official documents, the letters of administration. Does that bond really, truly have to be in place before those papers are signed?
And the answer is a big, resounding yes. The law could not be clearer on this. That bond is the absolute mandatory gateway. It's the final lock that has to be turned before anyone is officially given the keys to the estate. It's all about protection.
Okay, so we've established the bond is mandatory, period. But what happens when the will, the final wishes of the deceased, says something completely different? This is where things get really interesting. Section 2 sets up a classic legal showdown, the testator's will versus the court's power. You see, it's pretty common for a will to say something like, I trust my executor completely. They can serve without a bond. The person who passed away, the testator, probably wanted to make things simple and show how much they trusted the person they chose. And on its face, that seems like a pretty clear instruction, right? An exception to the rule. But, and this is a huge but, the court always gets the final word. Always. See, the court's #1 job is to protect the creditors and the heirs, and that duty overrides anything written in the will. So if the court sees any red flags, maybe the executor's financial situation has gone downhill, it can absolutely step in and say, sorry, will or no will, you're posting a bond. Okay, let's test that principle. The will says no bond required, right? But then you get a little tip that the executor might be in some serious financial trouble, maybe even heading for bankruptcy. What do you think? Can the court do anything about it? You better can. The court's power to protect the estate is paramount. It trumps everything else. An executor's potential insolvency, that is a classic change in circumstance, and it gives the court all the reason it needs to step in and demand that bond to safeguard the assets. All right, we've covered a single administrator, but what happens when you have a team? More than one person in charge of the estate. Section 3 tackles exactly that, how bonds work when you've got co-administrators. So the court basically has 2 choices. It can say, okay, each of you gets your own separate bond. This means you're only on the hook for your own actions. Or it can require one single joint bond. And that's where things get tricky, because with a joint bond, you're all in it together. Your liability is intertwined. And that right there leads to a massive question about liability. Think about it. What if you have 3 people on a joint bond and just one of them does something wrong, like dips into the estate funds? Are the other 2 in trouble? The answer is yes, 100% yes. When you sign a joint bond, you're creating what lawyers call joint and several liability, or solidary liability. And that's a scary term because it means the estate can go after any one of you for the full amount of the damage, even if you were completely innocent. It makes that decision to go with a joint bond a really big deal.
Okay, let's shift gears a little and talk about a very specific role that comes up in Section 4. We're talking about the special administrator. Just think of this person as the temporary guardian, the pinch hitter for the estate, who steps in when there's a delay or a dispute over who the permanent administrator will be.
Now, because this is just a temporary gig, their bond is super focused. It's not about managing the whole estate for years. It's all about one thing: preservation and a clean handover. Their whole job is to make an inventory, account for what they're holding, and then deliver it all safely to whoever is appointed as the regular administrator.
So let's really nail this down. What are the exact conditions of this special temporary bond? And more importantly, when does the special administrator get to breathe a sigh of relief and know they're off the hook?
It's actually really simple. Their job is to inventory, account for, and deliver the property. That's it. The moment the permanent administrator is appointed and signs off that they've received everything safe and sound, the special administrator's liability just vanishes. Job done.
All right, we've gone section by section, piece by piece. Now it's time to zoom out and pull it all together to really see the core principles that make Rule 81 tick.
And this summary table does a fantastic job of laying it all out. You can see, clear as day, how each section we've covered, from 1 to 4, has its own subject, its own core rule, and a very specific purpose. It flows perfectly from safeguarding assets in Section 1 to ensuring accountability for the temporary custodian in Section 4.
Okay, for everyone studying for the bar, or for anyone who just wants the must-remember points, listen up. This is it. If you remember nothing else from this explainer, remember these 6 things. Number 1, no bond, no authority. Number 2, it's a jurisdictional prerequisite. 3, the court's discretion beats the will. 4, joint bonds mean you share all the risk. 5, special administrators get their own special bond. And 6, if you violate the bond's conditions, you're going to be held liable.
And really, this whole discussion boils down to one powerful idea. When it comes to protecting an estate, trust is good, but a bond is better. You know, this rule gives us a fascinating glimpse into how the law tries to balance respecting a person's final wishes with the cold, hard reality of protecting the people left behind. And it leaves us with a great question to think about. Where exactly do we draw that line between personal trust and legal protection?